Alright, Appendix L, Consolidated Patent Laws, January 2023. United States Code, Title 35, Patents. United States Code, Title 35, Patents, Part 1, United States Patent Trademark Office, Chapter 1, Establishing Officers, Employees, and Functions, Chapter 2, Procedure of the Patent Trademark Office, Chapter 3, Practice before Patent Trademark Office, Chapter 4, Patent Fees, Funding, Search System, Part 2, United States Title 35, Patents, Part 2, Patentability, Inventions, Grant of Patent, Chapter 10, Patentability of Inventions, Chapter 11, Application for the Patent, Chapter 12, Examination of the Application, Chapter 13, Review of Patent, Trademark Office Decision, Chapter 14, Issue of Patent, Chapter 15, Plant Patent, Chapter 16, Design, Chapter 17, Secrecy and certain inventions, filing application in foreign countries, Chapter 18, Patent Rights and Inventions without federal assistance. Then it skips to United States Code Title 35, Part 3. Chapter 25, Amendment, Correction of Patents. 26, Ownership and Assignment. Chapter 27, Government Interest in Patents. Chapter 28, Infringement Act of Patents. Chapter 29, Remedy of Infringement, Patent, and Other Actions. Chapter 30, Prior Art Citations, Office Ex Parte Re-Examination of Patents. Chapter 31, Interparts Reviewed. Chapter 31, Optional Inter-Parties Re-Examination Procedure. Chapter 32, Post-Grant Review. Part 4, Patent Title 35, Patent Cooperation Treaty. Chapter 35, Definition. Chapter 36, International Stage. Chapter 37, the National Stage. Chapter 38, International Design. Part 5, the Hague Agreement concerning the International Registration and Industrial Design. Chapter 38, International Design Application. Selected Provision, Other Titles of the United States Code. Selected Provision, Title 18, United States Code. Uncodified Laws, select Uncodified AIA Provisions. Part 1, United States Trademark Office, the Establishment Powers, Duties, Officers, Employees, Restriction Officers, Employee with an Interest, Part of the Patent Trademark Office, Public Advisory Committee, Patent Trial, the Appeal Board, Board of Patent Appeals, Interference Library, Classification, Certified Copies, Publication, Exchange of Patent, Copies of Patent Application in Foreign Countries, Copies of Patent Applications, Public Libraries, Annual Report to Congress. Alright, Chapter 1, Establishment. Alright, Chapter 1. 1235 U.S. Standard Code establishing the United States Patent Trademark Office of the Agency of the United States of the Department of Commerce carrying out the function of the United States Patent and Trademark Office shall be the policy, direction, Secretary of the Commerce, or otherwise shall retain responsibility for the decision regarding the management and administration of the operation, shall exercise the independent control of the budget, allocation, expenditure for the personal decision process, the procurements, other administrative management function in accordance with the title and applicable provision of the law of those operations are designed to grant the issue patents of the operation with the design and facilitate registration, trademarks, and would be treated separate operating units within the Office of the United States Trademark Patent Trademark Office shall maintain the principal office of Metropolitan Washington, D.C. serve as a process for the paper for the purpose of carrying out the function of the United States with the trademark office shall be deemed for the purpose of the venue of civil action of the resident of the district with the principal office located except with the jurisdiction otherwise provided by the law of the United States Patent Trademark Office may establish satellite offices within such of the place of the United States with the consider the necessary appropriate conduct for the business. Reference to the purpose of the title of the United States Patent Trademark Office shall also be referred to as Office and Patent Trademark Office. Title 35 U.S. Standard Code 2 Powers and Duties. Engine with the United States Patent Trademark Office subject to the policy with the direction of the Secretary of Congress. They shall Commerce, the Secretary responsible for granting, issuing of the patent, regular registration, and the trademarks too, but they shall be responsible for disseminating public information with respect to patent and trademarks. The specific power of the office shall adopt and use the seal of the office which shall be due judicially notes which letter of the patent certified with the trademark registration papers issued with the office of the authenticated may establish regulation not inconsistent with the law, should govern the conduct proceeding of the office if they shall be in accordance with section 553 of Title 5, shall facilitate expedite of the process of the patent application, particularly those who file and strive with the process of search and retrieve it electronically subject to the provisions in section 122 relating with the confidential staff of the application. B, with the D, with the main government with the recognition, contact with the agent, for the attorney, with the other person representing with the application over the parties, with the party before the office may require them before they being recognized representative of the applicants for the other person to show that any with a good moral character, reputation, with a positive for the necessary qualification for the render the application over the person valuable service of advice for the assistant with the presentation, prosecution of the application with the other business for the office. Shall recognize with the public interest of continuing safeguard broad access to the United States patent system through the reduced fee with the structure with a small entity, section 41H1, E with the provide with the development of the performance-based process, including quantitative and qualitative of the measurements, standing with evaluating cost effectiveness, consistent with the principle for the imperability and competitiveness. G may be subject to any condition prescribed by the director or request for the patent application provided with the prioritization examination application for the product, process for the technology, important to the national economy, national competitiveness without recovering the graded extra costs. Finding such prioritization, nothing but stand section 41 other provisions of the law may acquire with the construct, the purchase, lease, hold, the manage, operate, improve, the alter of the renovate any of the real person mixed property interest therein and consider it necessary to carry out the function. 4A, make such purchase of the contract, the construction, management, operation, facility, the contract, supply, services without regard provisions, subtitle 1, chapter 33, of title 40, division C. Except sections 3302, 3501B, 3509, 3906, 4710, and 4711, subtitle 1, title 41, McKinney-Ventnor Homeless Assistance Act. B, may enter within and perform such purchase of the contract of the printing service, including the process of composition, plate making, press work, silk screen process, mining, microform and products of such processes as if considered the necessary to carry out the function office without regarding section 501 through 517 or 1101 through 1123 of Title 44. May you, with the consent of the distributed equipment and personnel, with the facilities for the other department agents for the instrument, with the federal government reimbursement obligations for the cooperative for the other department agents for the instrumental, establish use services for the equipment and facility for the office if they may want. When the director determines whether a practical, efficient, and cost-effective to do so, may, with the consent of the United States of the agency, instrumentality, patent, trademark, office of the international organization concerned, services, records, and facilities personnel, any of the local government agencies, instrumentality, or foreign patent, trademark, office of the international organization perform the functions on its behalf. 7 may retain all of its revenues received, that include revenues and sale, leases, disposal of any real personal property, mixed property interests there of the office. 8 shall divide with the president and with the secretary of the conference of the national, certain with the international intellectual property policy issues. 9 shall divide the federal department agency for the immediate matters of the intellectual property policy for the United States for the intellectual property protection in other countries. Should provide guidance as appropriate to respect with the proposal agencies to assist with the foreign government and international intergovernmental organization matters for the intellectual property protection. 11. May conduct programs safe with the exchange of the items and services regarding the domestic international intellectual property law with effect with the intellectual property protection domestically throughout the world, with the office authorized to expand functions to cover subsistence expenses, travel-related expenses that include peer team lodging costs, of the transport costs of the person attending such programs of the non-federal employees. Shall divide with the Secret Secretary of Commerce program, shall studies relating to intellectual property with the policy with conducted, authorized to conduct with the cooperatively with the foreign intellectual property office of the international and governmental organization may conduct programs and studies described in paragraph A in coordination with the Department of State may conduct programs studies with the cooperative with the foreign intellectual program offices, international governmental organizations, with concurrency with the Secretary of the State may authorize transfer of the not exceeding with $100,000 in any year for the Department of State for the purpose of making special payment with the international governmental organization for state programs advancing international cooperation concerning patent and trademarks of the materials. C, clarification. Special payments under subsection B13B for the addition of the other payment, the contribution of the international organization described under subsection B13B shall be not subject to limitation imposed by law with the amounts of the other payment, the contribution of the United States government. Nothing subsection B to derogate with the duty of the Secretary of State with the duty of the United States United States Trade Representative set forth in Section 141 Trademark Act of 1974. Nothing in subsection B shall derogate with the duties of the function registered copyrights or otherwise all current authorities relating to copyright matters. 4. An exercise of the director power under the paragraph 3 and 4A and subject B, with the director shall consult with the Administrator General, serve with an exertion of the director's powers and duties under subsection. The director shall consult with the registrar of the copyrights of the copyright-related matters. Deconstruction. Nothing in this section shall be construed, nullify, void, cancel, interrupt any pending request for proposal of the contract issued with the General Service Administration for the specific purpose of the relocating or leasing of the United States Patent and Trademark Office. It's Title 35 U.S. Standard Code 3, Officers and Employees. Alright, Title 35 U.S. Standard Code, Officers with Employees under Secretary and with the Director. Journal of the power and duty of the United States with the Patent and Trademark Office to be drafted and Under Secretary of the Commerce and Intellectual Property, the Director of the United States Patent and Trademark Office, the title of the referred to with the Director who is a citizen of the United States who shall be the appointment of the President by with the advice of the consent of the same of the Director shall have the person and professional background and experience for the patent and trademark law. Duties in general of the Director shall be responsible for the providing policy of the Director of Management, supervision of the office, and the issuance of patent of the registration and trademark. The Director shall perform these duties in a fairly impartial and equitable manner. B. Consult with the Public Advisory Committee. The Director shall consult with the Patent and Public Advisory Committee established in Section 5 of the regular basis of the matter relating to the patent operation of the office. Consult with the Trademark Public Office Advisory Committee established in Section 5 a regular basis on the matters relating to the trademark operation of the office. Serve and shall consult with the respect of the Public Advisory Committee before submitting a budgetary proposal for the office management budget, changing or pursuing a change of the patent trademark user fee for the patent trademark regulation is subject to the requirement to provide notice and opportunity for the public and under Section 553, Title 5 of the case B. 3.0 for the Director shall be before the take of the office shall just show the fail for the duties of the office. If the removal of the Director shall be removed from the President, but the President shall be provided with notification. Any such removal from both houses of Congress, office of the employees of the office. 1. Deputy Under Secretary of the Deputy of the Director of the Secretary of the Congress upon nomination for the Director shall appoint with the Deputy of the Director under the Secretary of Commerce and Intellectual Property, Deputy Director of the United States Patent and Trademark Office shall be the best for the authority for the capacity of the Director and with the absence and capacity for the Director, for the Deputy, for the Director, citizen in the United States who had the professional background experience in the Patent and Trademark Law, Commissioner, appointment of the duties. The Secretary of the Commerce shall appoint with the Commissioner of the Patent and with the Commissioner of the Trademarks with regard to Chapter 33, 51, and 53 of Title 5 of the Commissioner of the Patent shall be the citizen in the United States with the demonstrated management ability, professional background experience with the patent law. Serve for a term of 5 years, the Commissioner for the Trademark shall citizen of the United States with the demonstrated manageable ability with a professional background experience with the trademark law. Serve for the term of 35 years. Commissioner and Patent Commissioner for the Trademark serve for the Chief of the Operating Officer for the operation of the office relating to patent and trademarks respectively shall be responsible for the management of the Director all aspects of the activity of the office for the effective administration of patent and trademark operations. The Secretary may reappoint Commissioners to subsequent the time of 5 years along with the Performance Commissioner set forth with the Performance Agreement. The subparagraph sub D is satisfactory. B. Salary and Performance Agreement. The Commissioner shall pay for the annual rate of basic pay but not exceed the maximum rate of basic pay of the Senior Executive Service established in Section 5382 of Title 5 with including applicable locality-based and comparability payment but may be authorized under Section 5304 H2C with Title 5. Compensation for the Commissioner shall be considered for the purpose of Section 207C2A with Title 18 to be the equivalent described in Clause 2 with Section 207C2A Title 18. Addition of the Commissioner may be the receiver of the bonus in amount up to but not in excess of 50% of the Commissioner annual rate with the basic pay with the base evaluation. Secretary of the Commissioner acting with the Director of the Commissioner in performance of the defined with the annual performance agreement between Commissioner and Secretary of the annual performance agreement that incorporate measure organization individual goals key operational areas delineated in the annual performance plan agreed by the Commissioner and Secretary payment of the bonus on subpay is made with the Commissioner with the only to extent with which the payment does not cause the Commission with the total aggregate with the compensation calendar year equal to the exceed the amount with the salary of Vice President under Section 104, Title 3. C. Removal of the Commissioner may be removed with the Secretary with the misconduct of the non-satisfactory performance of the performance of the agreement with the described subparagraph of the B with regard to the provision of Title 5 of the Secretary shall provide notification any of the removal of House, Congress, other officers of the employee of the director, appointment of such officers employee that include attorney with the agent, officer of the director for the consider of the necessary care of the function of the officer to define with the title, authority, duties of the officer of the employee delegate with the such power of the vested of the officer of the secretary may determine. Officers shall be not subject to the administrative statutorily imposed limitation on position personnel of the nose position personnel. Office shall be taken in action for purposes of applying with such limitation training. Examiners office shall be subject to the Congress proposal to provide an incentive of the program to retain employee of the patent trademark examiner, primary examiner grade higher of the eligible retirement sole purpose for the trading patent trademark examiners. National security positions, the director consolidation of the director of the personal management shall maintain a program to identify with the national security position, providing with the appropriate secretary with the clearance in order to maintain the secrecy with a certain inventions described in Section 181 with event disclosure, sensitivity, strategical information, interest in national security. 6. Administrative of the patent judges for the administrative trademark judge for the director for the may fix the rate over the basic pay over the administrative patent judges appointed pursuant to Section 6 of the administrative trademark judges appointed pursuant to Section 17 Trademark Act of 1946 is not graded for the rate of the basic minimum pay payable for a level 3 executive schedule under Section 5314 Title 5 payment of rate of the basic pay under the title paragraph shall not be subject to the pay limitation under Section 5306E or 5373 of Title 5. C. Continued applicability of Title 5. Officers employed with the office shall be subject to the provision of Title 5 relating to federal employees. D. Adoption of the existing labor agreements. The office shall adopt labor agreements which are in effect as of the day of the effect of the date of the Payment and Trademark Office Efficiency Act will respectfully audit such office as then in effect. E. Carryover of personnel. 1. From PT Patent and Trademark Office, effective the date of the Patent and Trademark Office Efficiency Act, with all the officers employed with the Patent and Trademark Office on the day before. Such effective date shall become officers and employees with the office without a break in service. 2. Other personnel with the individual who on the day of the effective date of the Patent and Trademark Efficiency Act with the officer employed with the Department of Commerce with the other officer with the employee under paragraph 1 transfer with the officer with the necessary to carry out the provisions purpose of this act. Such individual services of the position which the major function of the performance of the work and burst of the patent trademark office determined Secretary of the Commerce for the B. Such individual services of the position perform work support of the patent trademark office during least for the incumbent work of the time determined the Secretary of the Commerce. Such transfer would be interest for the office to determine the Secretary of Commerce control of the director. Any transfer of the paragraph shall be effective for the same effective the date referred to in paragraph 1 shall be made within the brackets of the transition provision. 1. Interim appointment of the director for the on and after of the date of the pay and trademark office efficiency act with the president shall appoint with the individual serve of the director for the date of the director qualified with the subsection A of the president shall make more than one such appointment under the subsection. 2. Continuation officer for the certain officer for the individual serving the effective administration commissioner patents for the day before effective the patent trademark office of the efficiency act minister for the commissioner patents until the day with which the commissioner patents appointed under subsection B for the individual serving the assistant commissioner for the trademark of the day before the effective of the payment trademark efficiency office of the efficiency act minister for the commissioner on the trademarks until the day on the commissioner trademark is appointed under subsection B. Alright, Title 35 U.S. Code 4. Restriction on officers of the employees have the interest of the parties. Officers of the employee with the patent and trademark officer shall be incapable of, during the period of the appointments of 1 year thereof, of applying for the patent or acquiring directly and indirectly except with adherence bequests any patent, any right interest in any patent to be issued by the officer, and patents applied thereafter they shall not be entitled to the priority date earlier than 1 year after the termination of their employment. 2. Title 35 U.S. Code 5. Patent and Trademark Office of the Public Advisory Committee. Establishing Public Advisory Committee appointment of the United States Patent and Trademark Office shall have Patent Public Advisory Committee, the Trademark Public Advisory Committee, with which have served the 9 voting members appointed by the Secretary of the Commerce, serve with the pleasure of the Secretary of the Commerce in each year. 3 members shall be appointed with each advisory committee for a 3-year term of the shall begin with the December 1st of the year, and that any vacancy of the advisory committee shall be filed within 90 days after they occur. With the new member shall be appointed and fill the vacancy shall be appointed for the remainder of the predecessor term. 2. 2. The Chair of the Secretary comments for the Consolation Directors of the designee of the Chair and Vice for the Chair of the Advisory Committee with among the members underappointed or in paragraph 1 with the Chair of the resigns before completion of his or her term. Otherwise unable to do exercise of the function, Chair of the Vice versa shall exercise of the function of the Chair based on the appointments of members of each of the Advisory Committee. 1 shall citizens of the United States shall with each other the representative of the interest of the diversity each of the United States trademark officer of the respect of the patents in case of the Patent Trademark Public Advisory Committee with respect to the trademarks in the case of the Trademark Public Advisory Committee. Shall include member to represent the small, the large, in any application located in the United States, proportion number of the application filed with the applicant, but in no class shall be member of the representative of the shall in the small and any application include the small business concerned with additional inventors. Non-profit organization constitutes less than 25% of the members of the public advisory committee. Such of the members shall include at least one independent inventor. 3 shall include the individual substantial the background achievement in finance, management, labor relations, science, technology, office, automation, additional voting member of the advisory committee shall include the representative of each labor organization recognized by the United States Patent and Trademark Office. Shall represent the non-voting member of the advisory committee to be appointed meetings. Each advisory committee shall meet with the call of the chair of the agenda of the chair of the duties of each advisory committee. Review the policy, goals, performance, budget, user fee for the United States Postage Patent Trademark Office with respect to the patents in case of the public patent advisory committee with respect to the trademarks in this case of the trademark public advisory committee with the director of the matter. A, within 60 days of the end of the fiscal year, 2, within 60 days of the end of the fiscal year, prepare for the annual report with the matters referred to in paragraph 1. B, transmit with the report with the Secretary of the Commerce, President of the Commercial Community Judiciary of the Senate and House of Representatives. C, publish a report, official gazette of the United States Public Patent and Trademark Office. E, compensation. Each member of the advisory of the committee shall be compensated for each day of the individual, including travel during with such member attending with the meetings and conference advisory committee with the others engaged in business advisory committee, meaning the rate which daily equivalent annual rate with the basic pay in effect for level 3 with the executive schedule under section 5314 title 5. While away from the member's home with the regular place of the business and such member shall be allowed with the travel expense to include per diem and a label lieu substance authorized in section 57305. 5. Access to information. Members of each advisory committee should provide the access to recorded information United States Patent and Trademark Office except for the personal privilege of information concerning patent application required to be kept confidence in section 122. Applicable concerns of ethical law. Members of each advisory committee shall be special government employees meaning with section 202 title 18. H. Incapability of federal advisory Community Act, the Federal Advisory Committee Act of the National not apply to each advisory committee. Open meetings of each advisory committee shall be open and public except for the advisory committee majority vote executive section considering personnel privilege and other confidential information. J. Inapplicability of the patent prohibition. Section 4 shall not apply to the voting member of the advisory committees. Title 35 U.S. Standard Code 6 Patent Trial and Appeal Board in general. The Office of the Patent Trademark Appeal Board, the Director, Deputy Director, Commissioner of Patent with the Commissioner of the Trademark, Administrative Patent Judges constitute with the Patent Trial and Appeal Board with Administrative Patent Judges shall be a person competent legal knowledge, scientific ability with apply with the Secretary Consolation of the Director, reference of the Federal Executive Board, rule, regulation, delegation, authority, document with the other pertaining to the Board of the Patent Appeals, interference deemed to refer to the Patent Trial Board. Appeal Board. B. Due to the Patent Trial and Appeal Board shall a written appeal application revised adverse the decision examiner's application patent pursuant to section 134A. Review appeal for the re-examination pursuant 134B. Conduct derivation proceedings pursuant to section 135. Conduct inter-party reviews and post-grant inventories. Post-grant reviews pursuant to chapter 3132. C. 3 members panels. Each appeal deviation proceeding post-grant review inter-parties review shall be heard by at least 3 members of the Patent Trial Appeal Board shall designate the director only of the Patent Trial Appeal Board may grant hearings. D. Treatment of prior appointments for the Secretary of the Common Secretary discretion deem an appointment of the Ministry of the Patent Judge before the date of the enactment of the subsection held office pursuant to the appointment of the Director taken effect of the date of the which Director initially appointed with the Administrative Patent Judge and show the defense for the change for the appointment of the Administrative Patent Judge based for the Judge having it being originally appointed by the Director of the Administrative Patent Judge appointed by the acting with a de facto officer. Title 35.6, Title 35, U.S. Standard Code 6, Pre-AIP, Board of Patent Appeals and Interference established. Composition, therefore, shall be the United States Patent and Trademark Office of the Board of Patent Appeal with the interference with the Director of the Deputy Director of the Commissioner of the Patent, the Commissioner of the Trademark Administrator of the Patent shall constitute the Board of the Administrative Patent shall person competent legal knowledge, scientific ability for the appointment with the Secretary of the Commerce, consultation with the Director of the duty of the Board, appeal for the interference with the written appeal for the review of the adverse decisions of examiners upon application of the patent shall determine the prior patentability invention. Interference declaration, section 135A, appeal for the interference shall be heard with at least 3 members of the board designated with the director only on the board of patent appeal for the interference may grant hearings. Authority Secretary of Commerce his or her discretion deem the appointment of the administrator of the patent and judgment before the date of the enactment subsection held with the office pursuant to the appointment of the director of the taken effect the day of the which the director initially appointed with the administrative patent judge. D. Defensive challenge and appointment in the defense of the challenge appointment and of the administrator of the patent judge, basic judge, having them had originally appointed the director of the administrative patent judge appointed acting on a de facto officier officer. Alright, Title 35 U.S. Standard Code 7, Library. The director shall maintain a line of scientific work of the periodic, both foreign and domestic, of the patent trademark office to aid with the office of discharge of their duties. Title 35 U.S. Standard Code Classification of Patents. The director may revise patent and classification subject to many United States letter patent and such of the patents printed publications may be the necessary practical purpose to determine the readiness and accuracy of the novelty inventions which applications for the patents are filed. Title 35 U.S. Standard Code 9, certified copy of the record of the director may be furnished, certified copy of the specification drawing with the patent of the patent trademark office, the other records available to either the public or to person applying thereof. Title 35 U.S. Standard Code 10, publication. The director may publish and print with the typewritten electronic form following patent published application on the patents, including the specification drawing with a copy of the same of the patent trademark office that may be printed with the heading for the drawing of the patent and the purpose of the polygraphy. 2 certificates of the trademark registration, including the same of the drawing with the copies of the same of the official gazette of the United States Patent and Trademark Office, the annual index patent and patent patentees for the trademark registration, annual volume for the decision patent trademark cases. 6 patent pamphlet copies of the patent laws, rule of the practice law of the rule of the relating the trademark circulated with the other publication relating the business of the office. The director may exchange with the publication specified in the items 3, 4, 5, and 6A of the section publication desirable to use of the patent trademark office. Title 35 U.S. Standard Code 11, exchange with the copies of the patent applications in the foreign countries. In general, the drawings may be exchanged with a copy of the specification drawing with the United States patent, but the published application patent, but those of the foreign country, but the director shall not enter the agreement that will provide such for the copy of the specification drawing with the United States patent. Applications of the foreign country other than the USMCA, a country with a WTO member company without the express the authorization Secretary of the Commonwealth definition of this term, the USMCA, the have the meaning of the terms United States, Mexico, Canada Agreement and Implementation Act, and the term WTO member country has the meaning of the given in Section 210 Ugaria Round Agreement Act. Title 35, United States Code, Chapter 12, copy of the patents application public library. The director may supply a copy of the specification drawing with the patents published applications for patents in printed electronic form in a public library of the United States, which shall maintain with a copy for the public at the rate of each year of this issue of the established pursuant in Section 41D. Title 35 U.S. Standard Code 13, annual report to Congress. The director shall report with the Congress no later than 180 days at the end of each fiscal year of the money received with the expended by the office for the purpose of which the monies were spent, with the quality of the quantity of the work over the office, the nature, training with the provide with the examiner, evaluation commissioner of the patent, commissioner of the trademark, secretary of the commerce, the compensation of the commissioner, and the other information relating to the office. Chapter 2, proceeding in the patent trademark office.